I thank the Honorable Minister of State for Electronics and Information Technology, Shri Rajiv Chandrasekhar ji, for joining us for this stakeholder consultation on the draft bill for the Digital Personal Data Protection Bill today. And I thank all of you, which represent a very wide cross-section of expertise and knowledge available on this subject, to coming to participate in today's session. We'll all be greatly benefited in improving our bill and thinking right about the bill with the help of your inputs. While we have opened it up for public comments in a structured fashion, and we have extended the time till the 2nd for that through the MyGov platform. Nevertheless, it is immensely useful to have a chance to hear you, because nothing enables us to understand perspectives and issues better than actually hearing you in person. With that little preamble, I'll request Honorable MOS to take this forward. Thank you.
Thank you. My colleagues in the ministry, Amit Agarwal, Rakesh Maheshwari, and ladies and gentlemen, thank you for being here on the weekend before Christmas. So that in a way it is reaffirming the deep interest that everybody has in the way we are moving forward in creating this framework of new laws and legislations for the digital economy. As I have said in the past, and I repeat again, that what we are doing today at this current time is building out a framework of new legislations and a new framework of policies that will catalyze and will serve as a propellant for the momentum that we see today in the digital economy and in innovation in general. The three pieces, I have spoken about this in the past, I'll repeat this again, is of course the Digital Personal Data Protection Bill is one big element of that. There is going to be very shortly around the corner a Digital India Act, which will be also available for consultation, which is the successor, if you want to call it that, to the IT Act. And then we have an overall framework of the National Data Governance Framework and Policy that deals with all things government and all things anonymized and all things non-personal in terms of data. So the starting point that I just want to leave behind with you is that there is this framework and architecture that has been developed. And what we are today engaging with you on is one important and narrow piece of that framework. The objectives of the DPDP bill are extremely clear, and the bill and its index and its contents laid out. It is, of course, to prevent the misuse of personal data, which is a widely known, and there's been plenty of angst on that. The misuse of data and reciprocally the protection of consumers' personal data and the affirmation of the consumer, the citizen's right to have his or her data protected. The second objective of this bill is, of course, to do that in a manner that continues to not create a compliance-intensive framework, as some other geographies have sought to do. To continue the innovation, continue the momentum of growth of the digital economy, entrepreneurship, startups. And third, as the government itself digitizes, create a framework of legitimate purpose and legitimate interest in terms of the government's own access to data as the government seeks to proceed forward and improve its governance. So these are three broad frameworks. I will not go too much into the detail. We will listen to you. This whole idea is to engage with you. And obviously, I don't want to make a long speech on it, even though it is tempting to make a long speech on this. I will not. And we will just open it up so that you can comment on specifically the sections of the bill that you have an idea on, suggestion on, or a problem with. I would request you not to make long-winded speeches about the philosophy and ideology of privacy and data protection, which I have to deal with anyway on a regular basis as experts come into my office and impose their gyan on me. So I will request you, it's a Friday afternoon, so we will go easy on the gyan. We will go deeply into the bill and your views on the bill. So with that, I hand it over to Rakesh, who will run the engagement.
Thank you, sir. We have around 85 people as of now joining us to DC also. So once again, thanks a lot for joining with us and sharing your valuable feedback and recommendations. Make it a very practical, interactive session, while and of course also very useful. Therefore, I request all of you maybe to raise your hands before asking the question, and as we have the eye contact, as we agree to the question, please tell your name, the organization, the clause number of the draft data protection bill, and the question that you have. With this, we leave the floor open to you.
Thank you so much, sir, for giving this opportunity to provide our inputs. And I'm Kamesh Shekhar. I represent the Dialogue. We are a tech policy think tank based out of Delhi. So, sir, like I had just a question, also like a little bit of a comment on the clause 17. Which talks about the cross-border data transfers. So obviously you have also mentioned a couple of times that like what is the terms and conditions and etc. would be spoke about as through the legislations which will, I mean, the subordinate legislations which would come. So like is it possible to give a little bit more like clarity in terms of what are the process and the parameters could be, you know, part of that notifying the countries? And also would there be an option for existing mechanisms other than the notifying countries like BCR or like SCCs could be part of this you know, transfer mechanism itself would be very helpful.
What is an SCC?
Contractual clause yeah, stuff.
So here is the basic fundamental principle that will drive the notification of additional geographies where data can be stored, personal data can be stored. A, that this law and therefore the rights of the consumer or the citizen whose data is in question must be enforceable in that geography. So nobody can hide behind, I've crossed the border of India and therefore the law doesn't apply. So it will only be those countries that agree, either reciprocal agreements or whatever, whether if the law automatically allows it, for this, the rights of these Indian citizens whose data may or may not be stored in those geographies to be enforced there. Second is, as I said, there is a certain amount of reciprocity as we look to the future of digital trade and corridors of trust. I use this phrase that in the post-COVID world, there are going to be increasingly, in sort of this globalization and this free for all and free flow of data with trust, there will be these corridors of trust that will be built between India and other like-minded countries. And those corridors of trust will be characterized by, like I said, one very important element will be the enforceability of the rights of the Indian citizens there. And reciprocally, the ability of the government, especially the LEAs, law enforcement agencies, to access data in the events of national security and other emergency situations. So mota, that's the broad thing. Of course, we have left it to the government and the Ministry of Home Affairs to notify these the countries. So, but I can suggest to you that these are the criteria that will be looked at. Sorry. I picked it
Good afternoon, sir. Sir, I'm Abhishek from Cyber Peace Foundation. We're a cyber law and policy think tank. So just to put it in contrast with the previous bill, so do we see any provisions which is actually addressing to the data classification in terms of critical, sensitive personal data? Because as the title of the bill itself says, digital personal data, is there any other possibility of a non-personal data bill as well?
The answer is no. There is no provision for a non-personal data, but I can tell you that the Digital India Act will certainly deal extensively about the issue of non-personal data, the rights of the non-personal data and its use, especially by a lot of big tech companies that effectively take the personal data and then anonymize it and then have a free pass in a sense about the use of that because it is non-personal data. There is a fundamental question that needs to be asked and answered, which is if a non-personal data is derived from somebody's personal data and that person is Indian, and there is monetization of that non-personal data, the benefits of that should accrue to whom? Who owns that non-personal data? What are the rights of the original provider of the personal data vis-a-vis that non-personal data? So those are some of the issues that we will discuss in the context of the DIA. This is, like I said, a very narrow, very specific, very focused bill that deals with the citizens' rights to data protection and the reciprocal obligations that are cast on the platforms that collect that data and use it to provide a data product or service.
Thank you, sir. My name is Amrita Chaudhary and I represent CCUI. Few questions and comments. Thank you for having the stakeholder discussion. Firstly, we have termed harm with 4 provisions. However, when we look at cyber harms, psychological and mental harm is also something which happens, especially with children. So I think that needs to be considered. In section 4, chapter 4, section 17 on cross-border, my question is, how would cross-border data flow and the data localization provisions interplay, if there are some examples? The third point which I would want to make is, in the bill, there are various provisions, statement made as would be prescribed. We understand it is for flexibility, but perhaps if there could be some consultation when those are being deliberated, it would be greatly helpful. And lastly, while we understand the child is anyone below 18 years, but looking at how the digital world works, perhaps we need to look at it a bit. Similarly with the consent mechanism, because parents may not be in the platform, or parents may not have that much of understanding. So are we going to look at alternative mechanisms for consent, or are we going to look at a graded approach? Thank you so much, sir.
Yeah, so in the context of the child, the provisions related to the children, if you have any suggestions, my suggestion is give it to us. This is what we have come up with. This is what we believe is right. If you have any alternate formulation, please feel free to suggest it. Our objective there is clearly we do not want to allow child exploitation. We certainly don't want many companies or platforms that intend to deal with children to have a framework that is equivalent to when they deal with adults. So that is a broad premise. If you have an alternate set of ideas, we are completely open to having that conversation. On no, I didn't finish. I'm finished. She had asked 5 questions on me. So on the issue of consultations, I think by now we have established a track record that for everything that we do, and this is the direction and the vision of our Prime Minister, that we will engage deeply with all the stakeholders who are impacted by the law or the policy. So before the bill, I can tell you that before we take the bill to Parliament and or to the Cabinet, we will frame the regulations that we have said will be prescribed. So we will not go in there and say in sometime in the future. Third is, I just want to tell you the subordinate legislation, the idea. It is not for giving flexibility. And this needs to be understood, and I'm sure most of you will appreciate it. In the tech space, we have a clear understanding that the policies and rules and laws have lagged behind innovation for decades. We don't want to do that anymore. We want to be, if not at pace with the innovations and the user harms and the new challenges, at least within striking distance of it. So therefore, we have said that instead of constantly hard coding things into the law and having to go back to Parliament every time for amendments and debates and so on and so forth, which essentially makes the gap even further between the harm and the law that is prescribed to mitigate that harm, that we would have these rules and regulations that will be formed after consultation, but there is a faster way to implement them. For those purists and absolutists who think that this is in some way shortcutting Parliament, it is not, because all subordinate legislation have to be placed in Parliament. and is subject to the scrutiny of Parliament. So it is no shortcut that is anybody is taking here. So I just want to say that. Yeah, you're doing the yeah.
Thank you. So this is an extension of what she said, but with a different flavor. I represent the United Health Group in the healthcare industry. My name is Swati. When you look at it from a healthcare standpoint, when you look at deemed consent, right, you've identified in Section 8 that it's only for emergency. Point one is that when you look at healthcare, it's important that even if it is in a non-emergency environment, the whole process of healthcare should be so managed that deemed consent becomes natural to it. That's the only way we will be able to quickly analyze, manage larger macro situations and what have you. In addition, in Section 10, we talk about parental consent, and that's why I'm saying I'm alluding to what she said. It also states that you require parental consent for everything the child does, especially if the child goes online. Now I'm giving you a healthcare lens, and in a healthcare lens, again, I think it'll be good to have deemed consent, or it is expanded to include healthcare, so that under parental consent, there are times when you cannot share everything with the parent, or they might not understand to the extent possible. For example, mental health, suicide watches, which are also something that, you know, the child can look for when they go into the online space. So I would say that perhaps healthcare has to be treated a little differently. And if the ministry could have a consultation with the healthcare industry to understand the nuances of what this could.
No, we will not have another consultation with the healthcare industry.
But
You are
yeah.
invited here.
Sure.
If you have a particular point of view in any of the clauses, submit your
We will definitely
formulation.
share.
That's,
We will definitely share.
yeah, and look, I'm not buying most of what you just said, just so
You're
that
not?
you understand where I'm coming from.
Yeah.
The issue is, if you make it clear in the consent to the patient that the data that is being sought is going to be used for A, B, and C,
Sure.
what you are requiring is a broadening of the purpose limitation principle in the bill.
Yeah.
It's nothing to do with deemed consent.
Yeah.
There will
Okay,
never
that's
be an opportunity for anybody to get deemed consent in the private sector. So that door is shut and locked, triple locked. So if you want to deal with the personal data of a patient, it's a great idea to have a very open, transparent consent mechanism. Explain to the patient what the consent is being sought for, what the data is going to be used for. And if the patient likes it, he or she will say yes. If the patient doesn't like it, he or she will say no. This is our construct and thinking. To this, if you want to have something to add, feel free to write a note, prepare a
Absolutely.
permission. But there will be no different classes of intermediaries that have different thresholds of obligation and different thresholds of obligations for the data principle.
No, absolutely. We'll not only share the information, we'll also share some global best practices that we
Yeah.
are.
This is Punya. I'm from Shardul Amarchand Bangladesh on behalf of ASSOCHAM. We would like to thank you for this opportunity and for some of the positives in the bill, which I would like to identify.
Some positives.
A lot of the positives.
And I make all this effort.
The compliance levels, it's not as compliance heavy. Ease of doing business has been increased. And we also like the fact that it deals with personal data and not non-personal data. We will be submitting detailed submissions later, but some of the concerns that we have are around the consent and the deemed consent provisions. First of all, while it's positive that the fact of deemed consent exists, the fact that it's being called consent means that there is a possibility for revocation of that consent by the data principal, which may not work in some situations, for instance, where fraud detection has to happen. And in those kind of situations, which the government intends for the consent to be given automatically. So that's one. And then second is increasing the grounds on which processing of personal data can take place to include contractual necessity and legitimate purpose, something which has been done around the world and we think is essential for business continuity and in business interest as well. So these are the submissions that we wanted to make.
Yeah, well, again, you submitted, but I don't see how this contradicts the obligation of taking consent and protecting the citizens' rights. If you think that you are going to waive a contract and say the contract implies that I don't have to take consent, then I will respectfully point out to you that you're very, very wrong. That's not the direction that you should go. That a contract cannot supersede the citizen's right to have his or her data protected. And his or her data protected will mandatorily require or build in the need for his or her consent to be taken. So if you're flirting with the idea that a contract somehow undermines the obligation of taking consent, I suggest that you don't. That's all I can say. But feel free to write in.
Then I come back.
Thank you. My name is I am a trainer to law enforcement agency, sir.
Yeah, we met.
Very small suggestion, sir. If we can segregate sensitive personal data from the personal data, because very rightly you are allowing right to forget. Now, some small data like phone number and email, which is not sensitive at all, if that is allowed to be forgotten, the company's database and the obligations will increase manifold, which will actually not serve any major purpose, because this in any case is a very common data which people are sharing. Second, my another request is, sir, that certain framework for cyber security and privacy by design, if you can prescribe as part of the mandate in the law itself, that will really help. Because otherwise, everybody will work according to his own whims and fancies, and there will be no standard. So if I am approaching a company, sir, how do I know whether they are compliant at all or not? Because you want to keep it light, which is fine, but there should be some framework.
So Anuj, two things I just want to share with you. And I think you had asked the question also about the sensitive personal data. There is nothing in the law today or the Supreme Court's observation that says that category of personal data must be treated as superior or inferior to the others. So this bill essentially addresses personal data, and that any breach of that personal data is a breach by the company that collects it. The issue of sensitive personal data, criticality of the data will come in the event when the Data Protection Board adjudicates the consequences of the breach. It is not for us as a government to say कि आप sensitive personal data 3 firewall के पीछे रखो, personal data 1 firewall के पीछे रखो, वो हम बोलेंगे नहीं और उसके पीछे जाइए everyone. एक दूसरा, आप जो कह रहे हैं ना कि privacy by design, this whole area is a departure from the conventional thinking that the government should be prescriptive. Thou shalt do this, thou shalt do this, thou shalt do this. No. This bill basically says, if you are a platform, this is your obligation, unambiguous. Thou shalt not misuse, thou shalt have purpose limitation, that thou shalt have storage limitation, and thou shalt have data minimization. These are principles that are legally enshrined in this bill. We will not do prescriptive laws going forward, because what is prescriptive today is not is hard coding going forward. So, ये एक directional change है. So you please understand that we are going in a different direction. The 2018 law did prescribe many things. You should have a privacy law, you should have this law, you should have that law. Here it is very clear that we are basically saying if you're a platform and you want to do business with, provide services to an Indian citizen, you should be pretty clear about what your obligations are. And the obligations, if you breach those obligations, be prepared to write a 500 crore check at the minimum. But a simple framework है मेरे हिसाब से.
Thank you, sir.
He is doing the, you'll have to catch his eye.
Thank you, sir. Good evening. My name is Sandeep Kathuria. I'm representing Broadband India Forum.
I
Sir,
can't
at the
hear you.
outset, I will say that the draft bill is a big step in the right direction. It aims to facilitate ease of doing business, sir, and develop India's digital economy while adequately protecting the privacy of the personal data. So it creates a very simple framework, and it recognizes the need for technology regulation to remain adaptive over time, like you have said, sir. Sir, truly a good step, sir. Sir, however, there are certain areas which may require guidance or deliberation.
Sure.
One is the definition of child, which has already been discussed, sir.
Right.
Secondly, sir, the definition of personal data the way it is written there, along with the definition of data, it makes it, in our view, sir, a definition bit wide. So if it can be made more precise, because ultimately it is a very practical thing, because one has to take a consent from the customers on specific points only. So if it can be related to some identifier, then
You please give it to us. I mean, I have heard people tell us that the definition is too narrow. And there have been people who have written to us and said that it has to be broadened. So aapka contra view hai. So you please look, we are open to it. You please feel free to submit. And like I said, the children's section for us is, we want to do this right. So if there's any other formulation for it, we are happy to look at it.
correct, sir. So there are two more points, sir. One is that the section 9, which deals with the data fiduciaries, it allows that personal data can be shared between data fiduciaries. That's a very good step, but the framework around it is not very clear that how will that happen, considering that a consent will be taken by the primary data fiduciary, how will it be passed on to?
Where is the sharing?
I think it's clause 9 last.
Which one? Just tell me where it is. What are you reading?
Section 9.
No, look, I'll be very clear on this. This clause is to make sure there is no prohibition. So if I give you my data and you decide to store it in a cloud that is operated by somebody else, there is no prohibition. But the obligation, the consent, the obligation of protecting the data is with the data fiduciary who has taken the consent and collected the data. There is no outsourcing of that consent, outsourcing of that obligation. So the primary data fiduciary that collects the data engages into this consented to agreement with the data principal has the obligation. And that data fiduciary may want to back his agreement with whatever indemnification and whatever contracts he has, service providers that he uses. So there is no ambiguity about where the obligation lies under this act. Please go ahead.
Or data processor.
Yeah.
And I think what the industry is wanting to put across is we agree the data fiduciary is the owner of the data and should be held responsible for the notification. We would prefer that only one, that is data fiduciary is the one responsible and not the data processor.
It is not the data processor. The obligations are, it starts and ends with the data fiduciary who has collected the data from the data principal. If the language needs to be made more precise, it will be made more precise.
Yeah, that's
but that is the intent of the act. No, processor will be liable to the data fiduciary. That is not that's not the government's problem. That is the nature of your contract.
Thank you, sir. This is Shashank Mohan from the Center for Communication Governance at the National Law University, Delhi. Sir, I would like to appreciate.
Can you speak up a little bit?
Yes, sir. I would like to appreciate the efforts made by the ministry and you, sir, to enable this public consultation. So I will make just two small points. So one is, if we could bring back the language on right to portability, sir, I think that would be helpful. That will really help the citizens. And I appreciate the ministry's efforts in making this law simple for the citizens to understand and also enable their rights. I think so it will enable their privacy rights and autonomy rights, and also, sir, enable some innovation in the industry so that the choice lies eventually with the citizen and the user. So that's one suggestion. So the other suggestion is I'm looking at clause 18, subclause 3. That's exemptions for data fiduciaries. So I was wondering if children's data exemption can be dropped from here. So in particular, clause 10, subclause 2, sir, which says that no harm shall be caused to any child. I think, sir, that should continue to operate for any fiduciary, whether they're exempted from certain provisions or not. So I just had those two.
So what is the point? Second point, I didn't get
Yes,
it.
so clause 18, subclause 3 says that the government can notify fiduciaries to which certain sections will
Yeah.
not be operable. So I was wondering, it says section 10, which is the section for the children's data. And sir, under section 10, there's a subclause that says no harm shall be caused to the child. So I think this should be operable even for exempted fiduciary. So that's.
So let me just tell you about that. That section is meant to
sir.
exempt early stage startups.
Yes, sir.
If that
Yes.
language needs to become a little bit more precise.
Yes, sir.
And certainly we don't want early stage startups to get a free pass in terms of children's data.
Yes, sir.
So
Yes, sir.
that agreed.
Okay, so that was a
we
limited
will
point.
tighten the language on that. That has been noted earlier as well.
Thank you, sir.
And on the issue of the other point you mentioned about
So right to portability.
see, look, here the right to portability has nothing to do with data protection.
Yes, sir.
It is to do with an inter se. The data ecosystem should allow data portability.
Yes, sir.
We think it should be in the Digital India Act. We agree that
Okay,
data portability is required,
Okay,
but we think it should be in the Digital India Act.
okay.
And if you, why don't you apply your mind on that?
Yes,
And if
sir.
you think it really needs to be here,
Sure, sir.
we are open to it.
Sure, sir.
We agree that the data portability should be a right.
Right.
Should that be a right given under the Digital India Act, where we
Right.
talk about all things data and all, including harm and all of that?
Right.
Or should it be here is something that is worth thinking about.
Sure, sir. Thank you, sir.
You'll have to just speak louder or.
A previous question. My name is Jiku Verghese from Malayalam Manorama TV.
Hey, we'll do media a little later. We'll do media later. I thought I recognized you.
Suhan Mukherjee, sir,
Yes,
from
sir.
PLR Chamber. So these comments are in my personal capacity.
Yeah, sure.
Over here, sir. The first comment I'd like to make, sir, is that what the bill is trying to do is actually provide statutory provisions for what is largely contained in the rules under 43A. In that, I do believe then we should apply the lens of 43A rules to the definitions and other provisions that we put here. And because let's understand 43A has also withstood the test of time when Puttaswamy and others were also going on in the courts.
Right.
So the definition of personal data that we have there is something that we could bring in here. The other definitions or obligations also are things that are found in certain sections here, and we should use the language which is there in 43A. I also believe 43A should not be deleted. Government should not give up the power to prescribe reasonable security practices and procedures insofar as information is concerned generally. Government should retain that power there. You can remove the bits that apply to what is defined as personal information. No, so I think compensation should also find a place in the bill because there should be remedies available to individuals. Two reasons. One is we are reducing then the remedies that are currently available to citizens. I don't believe that tort law actually provides a remedy because I had raised this comment and they were saying that tort is not a developed framework in India. Different courts have given different rulings on it because it's not codified in India. It's largely based on English law. So you may change the adjudicatory body. It doesn't have to go to an adjudicating officer as defined here. Also, if we want to meet the adequacy requirements of other countries, we have to retain the right for individual remedies. But that may be a strategic decision that we're not wanting to comply with adequacy from other countries because there are certain other elements also in the act which make us fall short of adequacy standards that are there. I'll come to that later. Similarly, sir, 72A, there will be suggestions that 72A should be removed. I don't think we should do that. Again, government should retain that provision there and retain it as far as information is concerned. Remove the personal bits from it. So we modify that accordingly. So as far as definitions is concerned, so we need to expand the definition of harms for sure to cover mental harms, the ability to undermine the autonomy of an individual through manipulation and things like that. That's very much needed. I think we need to define digital, digitized, as well as offline, because those have an impact on the exemptions bit of where the act applies. And that will lead to certain contradictions that are there. Also, sir, definition of public interest in 218. And you have deemed consent, which has a framework using the word public interest. That there needs to be a reconciling in that, in these two places. Also, where public interest is defined in 18.2, sir, I think 18A, the F should go. It could be read into public order, because this dilutes the standard of public interest to a great degree. Where we've said that public interest means in the interest of any of the following: sovereignty and integrity of India. F should be read in above that. So as far as adequacy is concerned, we may take a strategic call that we don't want adequacy recognition. That's fine as well. But if we are thinking of that adequacy as a standard that we want to meet, then we need to have the elements of an independent regulator that can make rules, and we need to have individual remedies, and you'd have to delete 18.1D from here presently, if we want to do that. As far as the board is concerned, so I have one comment that the board has currently contemplated for the functions that's contemplated. It doesn't meet the standards of the Supreme Court's orders under Roger Matthews and Madras Bar Association, these two cases, and we need to just modify the provisions around that appropriately. Sir, then I think there's one more place where government should contemplate, where government is processing data. There is a provision that by notification, there can be an exemption. But if private players are then providing services thereafter, the only remedies that government would then have would be contractual. And whether in case there is some sort of breaches that occur. Now, we need to contemplate on what would be a mechanism to ensure that there are slightly more effective remedies available to government in case those types of breaches do occur, or to a citizen. These are my comments.
I'll just make a few broad points, and then of course, whatever you have to submit, you please do submit. Number one, the lot of this that you are saying is based on your understanding of an architecture that is extremely prescriptive. This is my view. Okay, so I'm not necessarily getting into a debate with you. And that is not what we want to do, number one. Number two, on issues of harm and compensation for harm, like I said, the Digital India Act will prescribe a whole series of harms, including harms caused by breach of data and all the consequential impact of breach of data, like doxing, gaslighting, all of that. So this is not the place we will bring that in. And I think somebody else asked that question, and I said that as well. That is why we don't want this to be something that has an amorphous boundary. This is specifically to do with casting obligations on those who collect data and ensuring that they understand there are consequences to breaching the rights of the citizens whose data they collect. Simple. The Data Protection Board, Supreme Court will do this, Supreme Court will do that, all that is fine. We will deal with that when we is not a regulator. It is not meant to be a regulator. It has a very narrow single point job of independently adjudicating the penalties, the financial penalties arising out of a breach of any provision of this act. That's it. Now, if somebody says that also has to be a retired judge or a retired bureaucrat, I would argue that no, and we will very strongly make a case that it has nothing to do with regulators or tribunals or whatever else the courts have opined on. This is nothing to do with that. So most of what you have said, I have heard, it has been discussed in the past. I don't see it making any material difference to this, but that is not to say you should not submit it, and we certainly give it a good read and a good listen.
Thank you, sir.
You may want to move that side.
Next time, after this.
Thank you for hosting this consultation. My name is Pranav. I work with a global nonprofit called the Internet Society. And my views here are personal. And I have one question and one comment. My question is, we have come up with multiple iterations of the bill since 2018. I've been following them very closely. And I must applaud the ministry's efforts to have consultations at every occasion. And we've seen in all these iterations, in the past 3 iterations since 2018, we have had some mix of necessity, legality, proportionality. But in the current iteration, we have discontinued that those Puttaswamy protections that were earlier there to some extent with the use of the word necessity and proportionality.
We haven't used the phrases. you mean.
Yes, precisely.
We'll have the phrases.
I wish to understand the rationale behind such shift, given that it was earlier there, and how we intend to move forward there.
This is now we are getting into an academic discussion. Why are you not using the phraseology of that bill? Why are you not using GDPR? Why are you not using ABCD? This is what we have come up with. Basically, like I said, we have 3 very important objectives to meet: protect the consumer and the citizen, ensure that it is a compliance, non-intensive framework for the innovation economy, and create a very specifically carved out regime for the government to access data. I believe it meets the tests, all 3 tests: proportionality, legality, necessity. And if there is a reason for us to be challenged on that, we will more than meet that challenge. Now, have we specifically used those 3 phrases? If that is your input, we'll put that down the headline somewhere if you want. If that's your input. But it is absolutely consistent with what the Puttaswamy judgment has put forth as should be the DNA of a digital personal data protection bill.
Thank you so much, sir. I'll move to my second comment, sir, and
There's no harm. Yes.
Thank you, sir. I'm Riganki Nagpal from APN Partners. We're a law firm based in Delhi. First of all, thank you for doing this consultation. I wanted to talk about children's data. There's been a lot of discussion today about the framework for first-time users of the internet, particularly in the Indian context, where internet usage is often driven by children in the families and parents may not be as aware. So we would propose putting in place a framework for older teenagers, for example, in the ages of 15 to 18 years, to be able to give limited consent for electronic contracts. And you can also make a corresponding provision in the Digital India Bill so that children's rights are protected. Children are able to give limited consent for these specific purposes.
If you notice, the bill talks about consent managers and the government notifying periodically what are the innovations in consent management or new changes or new frameworks. So that should, in my opinion, give us enough flexibility to add elements to the consent architecture that today seems like it is the person or a consent manager on his behalf or her behalf. So, I mean, I think the framework allows for the consent architecture to evolve. And today, look, one of the things that all of you will agree is we are all operating on certain assumptions. And some of these assumptions will be proved wrong 6 months down the road, 1 year down the road, and we will need to change those. That is precisely why we have created the subordinate legislation. There is no playbook today that anybody has anywhere in the world that says this is a personal data protection bill that has worked perfectly. There is none. The only thing is the framework of GDPR, and we don't believe GDPR is what India needs.
Hi, sir. I'm Lakshay Narang from Dwara Research. We are an interdisciplinary think tank. We look at finance and tech policy. So my question is actually, I'm very glad that the objective of this bill is to create protection for citizens, and I think to that extent, right of grievance redress is an essential, a critical input to that. However, so if you read that with the duties that have also been mentioned, specifically which says that data principals should not raise grievances that are frivolous, but there is nobody defines who defines what frivolous is. And given the fact that, and so if you read both of them together, you allow data fiduciaries to sort of undermine their right of grievance redress because that is an undue pressure.
This problem was understood and discussed in the ministry when the duty part was inserted, that while not complying with the obligation of duties should not be a defense by the data fiduciary in the event of a breach. That's your point.
Yes.
And it is not. And if the language does not specifically specify that, we will add that. Our thinking is very clear. The duties are more of a aapko karna chahiye type thing, but that does not come in the way or cannot be used as a defense by the data fiduciary in the event of a breach.
Thank you, sir.
I thought that language is there, but it's not. Is there somewhere? The language is there. No, easy for the
So, sir, on your left, yeah. Hi. So my name is Varun from NASCOM, and just wanted to say, sir, thank you. The bill is much simpler. So there is definitely a lot more benefit in putting forward a simple framework and relying on rules for the details. There are, and coming from an industry lens where we're trying to figure out how practical compliance could look like, there are about 3 or 4 areas that I just wanted to highlight right now, and then we'll build on many other things in our submission. The first thing is that, sir, from what we understand, the intent is to exclude processing of paper records by humans. So if you use a computer technology at any point of time, computers are involved at some stage, that should be in scope. Unfortunately, there are like 4 terms that you need to interpret to actually figure out this scheme. So automated, offline, online, digitized. Is it possible for us to arrive at a slightly simpler construction where we just say that the act will not apply to processing of personal data that is not in electronic form? And that's something that we could look at. The second thing was, sir, that we were worried that while the emphasis on protecting children's rights is understood, the problem is that, sir, the concept of a data principle globally is known as one individual. That's what allows you to do data mapping in the real world also. But here we are conflating it in the case of children to both children and guardians. So the problem is that this concept, this definition for children becomes 3 people. So in the real world, that would mean that I have to treat the data of people that are unmarried and don't have kids separately and families separately, which seems to be conceptually a little confusing. So whenever I'm identifying and tagging children's data, I'll also have to tag their parents or their guardians' data as well. Because of the definition of data principle, it says that, in the case of children will include their guardians.
No, what data are you tagging? What are you proposing to tag?
No, so
point out politely to you that it's not allowed. Huh?
So where such individual is a child includes the parents or the lawful guardian of a child. So when I'm analyzing the phrase processing of personal data of a data principle, which is there in, let's say, clause 12, there's ambiguity as to whether that will mean the child or the child plus the guardian. So that's just slightly avoidable conceptually. I don't think that it really diminishes the protections to children, really.
This is in the context of consent.
Or generally also in the context of like other, yeah, it's a phraseology thing.
Write down and give us.
Yeah, thanks. One other thing was, and this was a question about, it's great that we've moved away from a purely consent-centric framework. In other jurisdictions, generally when data fiduciaries rely on grounds that are not consent-based, there are some requirements to maintain some kind of documentation that you've actually done that. So that you can then determine purpose limitation. But in our bill, we're not sure if that is actually intended or not. So when I do actually do some processing of personal data and I'm not relying on consent, there's no notice as such, right? So where exactly do I then record that what I've done is meeting the lawfulness?
No, I don't understand. Where is the question of processing data without consent?
When you're relying on one of the deemed consent grounds under 8, the entire clause 8. So when processing is necessary, 8.1 in a situation, 8.2 for compliance with the judgment, etc. So as a data fiduciary, if I don't want to go down the consent route and I want to see if I can fall within one of the categories in 8.1 to 8.9, there's no clarity about how exactly I can maintain records so that I can then discharge the accountability requirement that's placed on me under 9.1, which is that I actually have to show that I'm compliant with the act. But because there's no notice in these scenarios, how would we actually meet that particular requirement? That's one slight gap. And maybe, so for example, under the GDPR, when you get data from somebody else, like from another data fiduciary, or when you get data, when you're not relying on consent as a ground and there's no notice, you usually either maintain internal records, which could form part of your technical and organizational measures under 9.3, or you are required to maintain records which can then help you meet notice and information requirements in the GDPR. It's under Article 12 or Article 11 or something like that. So just in terms of how we look at how actually people maintain that.
I mean, if anything, we will then tighten the deemed consent.
Yeah.
If you're saying that the deemed consent section today allows for some processing of data without consent, and you are asking to provide for some accountability provisions in the bill, we will instead just tighten the deemed consent section.
Sure, got it, sir. I think we're on the same page. I think language will figure out. And just one last, okay.
The deemed consent section is really meant to be these exceptional cases where consent is not required or consent is not appropriate.
Yeah.
So the question of anybody then needing to get a notice or sending a notice doesn't arise. These are exceptional circumstances. And so if there is something in the language that makes it vague or open-ended, we will certainly tighten that up.
Thanks.
Can we now take some questions from VC?
Yeah,
because-
I have a suggestion on this deemed consent.
We'll just come. Let's just take a couple
So
of questions.
maybe because Mr. Srikanth from FICCI had raised this question first regarding consent manager, I request Mr. Srikanth if he can put up the question. Otherwise, of course, I will read it out.
Namaste, sir. Can you hear me? Can you hear me, sir?
Yeah, Mr. Srikanth, you may please go ahead.
Yes, if you can hear me, here is my, first of all, on behalf of FICCI, our compliments to the mighty for a very simple and easy to understand bill that hopefully can serve as a global benchmark in the years to come. We had a specific question on how the ministry is thinking of the role of a consent manager. Specifically, if they really have to be the agents of a data principal, should they be separate from a fiduciary? And therefore, should they be regulated separately and have their own roles and obligations to fulfill? That was my question. I hope you were able to hear me, sir.
Yeah. So Mr. Srikanth has asked about the role of consent manager. The specific question is how is the ministry thinking of the role of consent managers in order to be truly agents of the data principle? Will they be independent of the fiduciary? Is there a view on how they will be regulated?
The short answer is yes. I think we will be doing a separate detailed discussion on the architecture and design of the consent manager as we see it. They will be independent from the fiduciary, 100%. They will obviously not be independent from the data principal because they'll be acting on behalf of the data principal. And the whole idea of a consent manager is to those data principals who are unable to or find it difficult to adjust to the sophisticated nature of the consent that is being put out there by certain data intermediaries. The consent manager will step in and act on behalf of the data principal. This is broadly it, but the actual design and architecture of this and how it will work, we will be bringing it back and having a discussion on that.
So now I take question from Mr. Shailesh Gandhi. A fairly simple question. Section 29(2) should not allow DPDP to override RTI.
That's right, sir.
Yeah, okay. No, I mean, that's a point of view, but the
No, sir,
data
sir,
protection.
sir.
No, one second. I don't want to get a long debate on that. That's your view. You please put it on record and send it to us. Our view on this is slightly different, which is that the fundamental right to privacy is a fundamental right, and right to information is not. And if there is a conflict between two rights, the fundamental right prevails. That is our, let us say, commonsensical view on the matter. And I may be happy to hear your views on the matter.
Sir,
Please feel free to write.
This would make the right a right to deny information and take away the right to information completely. You might as well repeal the RTI Act. If you have 32, then it's actually a repealing of the RTI Act.
So we move to the next question, Mr. Darshan. So.
Online.
Yeah, online.
Yeah.
So Mr.
Sir,
Darshan, if you can.
Yeah. So sorry, I couldn't make it in person, but just a few points. Completely appreciate the concept of reciprocity. And we are all here for a free and fair internet. Just in addition, there is a request that a copy of the Indian data, Indian user data, should be kept in India. So it goes abroad for processing under reciprocal regime is fine. We're requesting that a copy of the Indian user personal data should be kept in India in such a regime. That's request number one. Sir, clause 9.2, this again as a citizen, obligation of the user to give 100% accurate information for queries asked by the data fiduciary, I think is huge overreach. They ask me my name, I'm fine. Maybe my telephone number, I'm fine. They start asking me how many kids I have and where they go to school. I'm going to not answer the question and pay your fine of 2,000 rupees. I think that's a huge overreach in terms of the obligation on the end user. So that's my point number 2. So deemed consent clause 8.7. Again, I'm an employer myself, so it hugely favors me. But as a citizen, I think giving unlimited powers to employers for a very wide range of usage of that personal data of its employees, I think I mean, we have to create a little bit of limitation in that. I will suggest some phraseology in my submission. And so last but not the least, on the penalty regime, so I feel it shouldn't be an absolute figure. Maybe it should be a percentage of turnover or something. So smaller companies get harmed less, bigger companies get harmed more because they should anyways be responsible. It's just a suggestion. Thank you.
Yeah, so now we can take questions once again.
Okay. Thank you, sir. I'm a Prajita. I run this organization called the Quantum Hub, TQH Consulting, and also WILAC, Young Leaders for Active Citizenship, which works with young people. So I just have 3 points. One is around, sir, I think you mentioned that, there will be rule making will happen through a consultative process, but if it could be included in the bill itself, some phrasing around it, like it's in the TRI Act, that would be really useful, so that all governments that come after this government, which is very consultative, remain to be consultative in the future. The second thing is, sir, that I think a lot has been discussed around.
This is a never-ending conversation. Put everything in the middle. Put you come to work at 9 o'clock and work 5 o'clock. Consultation, our track record for this is very clear. We believe that these bills have to work, these laws have to work, and we are consulting at every step to do that. Now, if you want it hard-coded in the bill, certainly I'm not going to be just advocate of that.
Okay, great. Sir, just 2 other things. On the cross-border data flows, I think it's very well appreciated that, you want to look at what the trade negotiations are with other countries. But just one suggestion, sir, there are so many global conversations around having cross-border data flows, such as the APEC system, which is the CBPR, and the OECD, which has come up with that. India has not been a participant to it. And while I can understand that India may not want to be an active participant, it may be good to be involved in some kind of discussion so that it's easier for industry. Otherwise, the negotiation process and the whitelisting process may take a lot of time. And the third thing, sir, when it comes to children, thank you so much for acknowledging that needs to be relooked at. We have worked on a framework which we will be submitting, which looks at the experience of other countries as well. But maybe something that can be done is right now reducing the age of consent, the age gate, so that in the rules that are prescribed, the government has more time to do a thorough consultation on this, and maybe even a large-scale survey of how actually internet is being used by children and their parents, because it's not just about children's privacy on the internet, but also their privacy in homes, which impacts women a lot more than men, girls a lot more than boys. So just a submission on that.
in terms of a cloud where I can store my data. It is better for me, price-wise, innovation-wise. But the criteria that will determine where this can be stored is going to be not digital trade. It is going to be where this law is enforceable, where the rights of the Indian citizen can be enforced. So that is one. Second is, I never said we are relooking at anything. Your choice of words. I said we are open to your views on everything, which is a very big difference. Relooking is an admission that we've got it wrong and you've got it right. There's a lot of effort and time that has gone into the section on children, but I'm open to, if you think you have a better way of formulating what we believe is the objective of the bill, which is to protect children's data from being misused. So there's no relook, but we are open to it. So, since you brought up the issue of trust with government, I have to push back strongly.
Is it not audible? Sorry. So my name is Ashray. I represent MPL. We're an online gaming platform. We're a startup. First of all, sir, thank you very much for the bill. I think all the startups will join me in thanking you for reducing the compliance burden significantly. I just have two quick points. The first one is regarding penalties. I think this has been raised before, but if it could not be an absolute number, it could not be up to a certain number in section 25 and the following schedule. If it could be certain percentage based, it would probably help startups a bit. And sorry, I'd pause. The second
That was what it was before.
Okay. Yes.
The percentage was what it was before.
Yes. And the second point was regarding the commencement timeline. If it could be that there would be a longer timeline for startups to comply with it, and with
That
a
we're open.
with a
We're open to that.
Right. Thank you, sir.
I'm surprised nobody has brought up, especially the think tanks, the issue of cookies and search engines and the exemption for search engines in this bill. I'm queuing people who haven't thought of that issue yet.
Good afternoon, sir. This is Gauri Gokhale. I'm a tech lawyer from Nishit Desai Associates, and I'm putting these comments in my personal capacity. We spoke about the consent manager, and the definition of consent manager as given contemplates it to be a data fiduciary. And if we see the data fiduciary definition, the data fiduciary determines the purpose and means of processing.
Right.
In this particular case, it is the data principal who's determining that, and therefore they are simply collating the consent. So maybe that, though the compliance wise, I understand that you want to put certain compliances, but as a concept, technically they may not be data fiduciary, right? The second
No,
thing,
they will be a fiduciary in the sense that they are going to be intermediating between the principal and the intermediary, and they are going to seek consent. They are going to seek consent from the data principal to be a consent manager.
right? But they are not determining the purpose. I'm just going by the definition
No, I think
of that.
the point you're making is that there is a difference in scope between consent manager as a data fiduciary and the data fiduciary at large.
It's a definition, yes.
Okay.
The second one is, sir, on section 8.3 on deemed consent, and this, this query used to come even in the prior FPDI rules, especially in the context of cross-border, enforcement of awards and things like that. It may be clarified that when we talk about any deemed consent for compliance with any judgment order, etc., it also would include a foreign order or judgment outside India or within India, because that question used to always arise under Rule 6 under the previous rule. The next, sir, is we have been talking about
No, but judgment doesn't explicitly mean cross-border judgment.
No, it especially when we have arbitration awards, etc., and they have to be enforced outside India, sir. We often get these questions, especially when the collection happens during that process.
Would you suggest that instead of saying under any law, the usual language under any law for the time being enforced in India?
But only in India. The question is if there are judgments of Indian courts, for example, to be enforced outside India, or even the arbitration awards to be from outside India, anything cross-border is not getting expressly covered here.
Why don't you send your specific suggestions on this?
Yeah. The next point, sir, is you spoke, and we completely agree that on the rules part, it has to be a fluid law. In the earlier rules, Rule 8 contemplated industry bodies to come up with their codes of, certain codes. Of course, that was from a security perspective, but can there be some thought process of co-regulatory mechanism where industry bodies evolve certain things which then are approved by the central government or otherwise?
What is regulate what?
Quite a few things which are supposed to be prescribed under the rules.
But there's nothing to do with the regulation. They're just prescription.
Yeah, so the
Like
prescription.
which
right.
countries can be stored in? Where is the industry coming into that?
No, I'm not talking about the countries. I'm talking generally. There are 18 places or 21 places.
None
where
of
there are certain
none of them have
prescriptions.
anything to do with the industry. There will be consultations with everybody,
Sure.
including industry. But what is the self-regulatory thing that you're talking
So
about?
there are certain procedural things, for example, how the verifiable consent has to be obtained of the parent, etc. So if there are any mechanisms where the industry, of course, there will be consultation, but because different industries will have different necessities. So just as a suggestion.
Dekh lo, you
Sure.
suggest it.
Sure. And I think.
In principle, we are not averse to SROs or
Right, sir.
independent bodies and so on and so forth. But don't think of these as regulatory
No,
frameworks. We're not
regulatory,
bringing any
not
regulation.
regulatory, sir. It's more of adoption of certain prescriptions. Yeah. And the last one, sir, on this section 10, it may be clarified, though, I mean, one can interpret, but it may be clarified that the deemed consent would also apply to children's data, which is the section
So
10.
that's the point that
which
is
is
made.
not.
We'll tighten the deemed consent section.
Thank you.
Hello, sir. I'm Ashif. I'm from Cuts International, which is based in Jaipur. I have a query on section 15, which is on right to grievance redressal.
16.
15.
15.
So the bill says right to readily available means of registering grievance with the data fiduciary and all. So I just want to understand that how does the government planning to make it more effective and trustworthy? For example, the earlier the government planned to set up a data protection awareness fund, which is now been scrapped. So I just want to understand your view on this. How does the government planning to move ahead and
on what?
On making right to register grievance.
Right to register?
Grievance
Now, how do you want the government to go ahead with it?
How the government is planning to make it more effective?
इसमें बड़ा स्पष्ट है कि all intermediaries today are mandated to have grievance officers and deal with consumer grievances. We have tightened that with the new IT rules and created a grievance appellate committee in the event there are intermediaries who do not deal with grievances. That the government will step in and will address those grievances or on an appeal to the government will deal with those grievances. The right to grievance is now part of the bill. That is, if, for example, I have asked for my consent to be withdrawn and the consent is not withdrawn, then there's a right for the grievance to be registered with the intermediary, with the data fiduciary.
So, for example, but Kurt's study shows that there are not many consumers who are aware of like avenues of registering grievance. So how does the government planning to like?
So that in any event is a broader issue that we are tackling with in the overall internet ecosystem, which is that currently, if you're a big tech company, the consumer, how does the consumer increasingly know that he or she has a right under the IT rules to content moderation, to registering grievances, to, if the grievance is not addressed, go to the grievance appellate committee. Iska thoda communication and awareness campaign chalana padega. We'll have to do it.
There will be some sort of a fund for this.
Fund? I don't know. Amit and Rakesh will tell me their funds. We'll make the consultations now ticketed events.
Hi, sir. My name is Akshay Chavla. I'm a sir here in the middle. So my name is Akshay Chavla. I'm a journalist with Media Nama, but this is a recommendation, not a question. Sir, the ministry has been quite transparent and a lot of press conferences have been held about the bill. But in the explanatory note, you say that any feedback received from the industry will not be made public. I wonder why this is happening. And if the government wants to be transparent, they should be actively releasing the feedback that the industry has sent to them. This will help journalists.
We should get together.
This will help journalists report better and understand why the government has gone with which provisions. Thank you.
I'm Sandeep from Geo. We have two small questions. The first is about this SPD, sensitive personal data. We understand that there is no intention of prescribing any kind of security measures for the companies to adopt for SPD as a separate category of data. We just wanted to understand the thought process, if there is any thought on empowering the data principal for the uses of its SPD, because it has a higher potential of harm. For example, obtaining explicit consent or informing the data principal that the data's SPD might be used or rather processed cross-border. So things like that, where it's about informing the data principal about the in forms of empowering him by explicit consent, informing about the cross-border transfer of the SPD, etc. So that was question number one. The second question we had was that as per the adequacy terms for the clause 17, we understand that adequacy is whitelisting of the countries based on the principles, which I'll just add one of the principles, which can be prevention of access of the foreign LEs to the user data. So based on that principle, this is going to be a lengthy process. As we have seen, even for GDPR, it takes 2 to 3 years for closing one agreement. What is thought to be the interim arrangement while this whitelisting is happening?
So the answer is very simple. There will be a transition period for the bill to come into effect. And that transition period will be adequate time for the government to take into account what are the implications of notifying A country, B country, C country or not. So like I said, there'll be an interim period. It won't just happen that we switch off the switch on a particular day. That is one. The second is on your point about sensitive personal data. Like I said, the mandate of this bill is to ensure that the consumer's right to protecting his or her personal data is codified and there's a law for it. And as I said, the principle here is that a data fiduciary is only going to take data that is absolutely minimum required for delivering the particular product or service and can't go fishing for data. Third is that there is a consent that is going to be asked and sought and given or not given by the data principal or the consent manager on his or her behalf. The sensitive personal data, if let us say you are a fiduciary and the service, as in case of health maybe, involves delivering a service that requires sensitive personal data, the consent will say that I need your consent for the sensitive personal data. I will deliver your blood test or I will deliver your health checkup or whatever it is. And after it is done, storage limitation, the data is deleted. Unless in the consent, there is an explicit requirement of the data to be stored by the hospital or by the medical care provider. So this is how it works. Now, in the event of a breach, now let us say the healthcare provider breaches the sensitive personal data and somebody else breaches regular personal data because that fiduciary has not collected anything but personal data. The consequences under the adjudication process of the DPP will be very different for these two fiduciaries. Inka lag jayega 500 crore times the 1,000 people whose data have been breached. So which is a large number, we should keep them reasonably focused on not breaching. And the other person may be 50 crores times 100. So that is where the sensitive personal data will come into play, which is the quantification of the penalties. To the extent that you as a fiduciary go looking for sensitive personal data when you have no business doing so, there is an explicit prohibition. You cannot. You can only take data or take that personal data that you require to deliver that product or service. So if I'm Zomato, I don't know if Zomato is here, I use Zomato a lot. You can't take my grandfather's name, my blood group, my all of this. You take my address, you can take my credit card, and that's it. And then you will be subject to requiring to delete it after the product is or the service is delivered. You got it? Yeah.
Just follow up. So the as you said, even for adequacy, we'll have the time gap. So I assume for this particular clause, it may be as long as 2-3 years.
Well, I'll introduce you to the Home Ministry and you can have a conversation. Small question, one is about the timeline for the big. So, doesn't it take down about 7 days? That we consider too slightly because the response time. What is 7 days? 5 days.
The complaint. So,
What
section
7 days? What is the 7 days?
14.2 refers that a data principal who is not satisfied with the response of a data fiduciary to a grievance or response.
Why should it be more than 7 days?
Because, no, because there is a requirement to respond and there may be more responses.
Actually, in the IT rules, it's 72 hours.
But in the Right to Information Act, it's it's more than that.
That was passed in 2000 something.
So there is a request, sir. I mean, that's the second is right to nominate.
As a matter of fact, there are people, citizens groups who are saying this should be made 72 hours. So slow.
No, I'm sure, sir. I mean, and the ministry has to, decide finally what is best.
I'm just kidding. I'm just saying.
Balance has to be achieved, sir.
No, look, I want to say one thing very clearly, and we are in a room, we are doing this conversation, and there is going to be, post the bill, a requirement of a deep behavioral change amongst intermediaries and fiduciaries. It is not business as usual. It is not expected to be business as usual. There is a certain amount of heightened sense of obligation and accountability to the citizen that will come, which is not just in terms of protecting it, also being in terms of responsive to the citizen. So my suggestion is, we are custodians primarily of the citizen, and we will of course want to work with industry and innovation as well, so that nothing comes in the way of their progress. But don't flag things that unnecessarily make it more difficult for the citizen or the consumer. 7-day window for an intermediary or a fiduciary to respond is absolutely reasonable. Going forward, and by the way, this is the tech world, and this is not nobody's writing a letter and an Indian letter and a postcard and sending it by India Post. This is all email, this is all on digital platforms, and therefore there is absolutely no argument that fiduciaries and intermediaries should not be more responsive.
The second point, sir, is on clause 15, where there's a right to nominate, and data fiduciaries, we feel, should not be burdened with ascertaining the validity of the nomination. And in case there is a dispute on nomination, should it be the board which is going to decide whether the nomination is correct? Who is going to be held responsible for that?
Explain that again.
So the person would.
Data principal has the right to nominate.
Yeah.
Where does the dispute arise?
With the data fiduciary, whether the nomination is correct or not.
So just like in a will, sir, nominations may be contested in future. Who's going to settle those contestations?
After the data principal dies.
Yeah, could be. I mean, it could be.
All nominations get called into.
हाँ, तो उसके लिए एक लीगल फ्रेमवर्क बना देंगे. I don't even see what the issue is. But are you contesting the right to nominate?
No, what I'm saying is that it should that also not be under the purview of the board?
I just made the full speech that the data protection board's only mandate is to adjudicate disputes arising out of data breaches and the financial penalties that have to be levied. They are not a regulator. They're not going to be sitting and looking around and addressing disputes. If there is a dispute arising out of this, a grievance that arises out of the act, the appellate jurisdiction for that is the ministry, the GSA.
What will happen is, sir, that, first there'll be a grievance. Then, the system would then have to really separate it out at the start itself, that, okay, this is not to go to the board and it is to.
I just said it. It is not the bill. The law said, the bill says it is not to go to the board. Now, if you insist on taking it to the board will just return it. कि मेरा काम नहीं है ये.
There are few suggestions.
ITI. ITI, Indian Telephone Industry. Okay.
So one is that section C of clause 4. It says that targeting of provision of business was public in India. Now what happens is when international impact to the international website, it is not officially offering the provision of business in India. Can the act still apply?
Yes, sir. Say that again, the provisions should apply to the process. Yeah, okay, what is the point?
Questions not clear.
It will apply.
I think typically nowadays that concept of systematic offering of goods and services, whether that concept applies, I think that is what the question is.
Yeah, the systematic offering, the concept applies, the application is there, otherwise it's not.
No, is there anything in the language that makes it ambiguous that you would like to correct or improve or? Take it.
That's the standard, but I think keeping a lower standard on application of the act is actually better for the citizen here. Because if it's systematic, then the bar rate goes up.
Yeah.
So it's.
Anyway.
Yeah.
Anything else? Okay. Anybody else on online?
Hi, sir. Anant Taneja from Ikigai Law. We're a law and public policy firm. So firstly, thanks again for the amount of effort that's gone into this. We really appreciate the consultations. Couple of points I want to make. One, on how this law will interact with sectoral regulations, right? So if you look at clause 29, which tries to address that. If we take the example of a localization mandate that say the RBI has imposed today, what we are struggling with in terms of practical terms is understanding whether this law is now in addition to that, or is there a conflict because there is no localization mandate, and so there is a clear conflict, and we're struggling very practically on how to interpret whether this is a situation covered in 29.1 or 29.2. So what's the thinking behind that, and then maybe we can make suggestions in terms of what the language can perhaps read as.
No, so it's not so much as 29 as much as it is to do with 17. Your issue is really how does
I mean,
17...
this is one example. There could be number of examples where other regulators talk about data or something to do with data or portability or any of those.
29 is very clear that this law, and therefore whatever this law and its subordinate legislation says, will prevail over any other law.
If there is a conflict, no.
Explain this issue has come up in a previous consultation. The point, one thought process is that because it says to the extent of conflict, this law will prevail. And if the government has issued a notification under 17, it will override RBI's localization requirement.
Correct.
And RBI will no longer be able to require people to
That's what I
locally
said,
maintain data.
Issues about 17 and how 29 impacts 17 and other statutory bodies that have issued rules under for localization.
Correct.
That is why I said it is the power is with the government to notify under 17. And when they notify under 17, they will take into account what everybody else is doing. What are the requirements of everybody? Now, what has caused RBI to do what it's doing? RBI obviously must have some logic. They have some requirements for which they are doing it. If those are true for 17, then localization will be essentially the default position of the government for all data. Or if it is the case that there has to be some data stored here, some data mirrored outside, that is again something that the government will say in its notification. So I don't see any possibilities of there being a conflict. As a matter of fact, this will do is reading 29 and 17. 29 says the primacy of this act. 17 says the government will then notify what will be the status of storage. And so the government will obviously apply its mind on that issue.
I do think it's 29 does say both things. One, this law will be in addition to everything else. Two, it will have supremacy, and that's where a little bit of that dichotomy I think is.
No, there's no dichotomy at all. Where's the dichotomy? Is that the privacy is a fundamental right, but data protection is a right of the Indian consumer. And so therefore, if there are two things in conflict, this bill will prevail. On that, there is no issue. Now, the issue is having this bill prevailing and there are already being an existing situation of rules prescribed by another statutory body on data localization. What is data localization or data storage under this law going to do to that?
Yeah.
That is your question.
Yes.
And that is precisely what the government will do when they notify under 17.
Sure. So just to follow up on how 70 is going to play out in practice. So thanks. I think in one of the earlier answers, you clarified that it's not going to be a switch which gets immediately turned off. So just want to understand how that's going to play out. Is there an expectation for data, perhaps which has already been there? Because that was one of the JPC's recommendations also.
We will see. We'll discuss this. Nobody will do this in a room, the three of us sitting down and deciding what. It will not happen that way.
Fair.
These are principles that are being written down in the law. How to actually operationalize something that is already midstream. I mean, it's not like the data economy is starting only after the law is passed. It is already happening. So how do we sort of harmonize those two? We will see and discuss it. With zero disruption. We don't want to disrupt industry. We don't want to disrupt any business model. But clearly we want behavioral change and a heightened awareness of the obligation to the rights of our citizens.
Thank you.
Can we have one last question and then we move to BC? Some 2-3 questions from there also.
Hello, sir. My name is John. I'm from Disney Star. I have one observation and 2 questions. And this is with regard to consent managers. One of the key characteristics of digital economy is disintermediation. So the disintermediation of the value chain. And here we are seeing, and I think we believe that that is one of the key characteristics of that is enabling innovation. But here we are seeing some sort of a middle man, if I may use that loosely, being introduced. The question is, could that be a friction or a facilitator to the whole process? And to my second question is that, will there be a fees that the consent managers will charge from the principal, from the data principal, or from the data fiduciary? Thank you.
So this argument cuts both ways because there is a general perception that data fiduciaries can also exploit data principals. And so therefore the consent manager is a way of protecting, especially the less educated and less digitally literate consumers in India, which there are, as you know, many crores of. So therefore the consent manager framework is designed to protect the interest of the citizen. Whether it makes it a little bit more difficult for data fiduciaries to deal with an intermediary who's a little bit more informed than a data principal, it probably does. But that's something that you'll just have to get used to. On the costing part of it, I really don't know what we have thought through on that.
No, at this point, sir, but obviously the subtext is that he who pays
as a consent manager, we have decided rules.
Yeah.
So we'll figure out whether it has to be costed. I can't imagine anybody doing it for free. Isliye, that's why, I mean, now, despite the lack of trust in us, we have specifically understood that this is an area that has to be designed and evolved. And we have not embedded this and said, this is what it should be. That is why we said as may be prescribed.
Yeah, so we are going on BC mode again and request Amol to please put up your question.
Thank you so much. My name is Amol Kulkarni. I work with Cuts International. I hope you are able to hear me clearly. Sir, just 3 small questions. And before that, we completely agree with you that there is a need for deep behavioral change by intermediaries and data fiduciaries in the interest of citizens and consumers. And we from consumer bodies can help you in ensuring that deep behavioral change And with that objective, my first question is that while the bill provides for significant financial penalties under Section 25, it would be great if such amounts can be used for the benefit of data principals. In previous versions of the bill and in other laws, there have been provisions to create a fund to be used in consumer interest, and something on those lines can be thought about here as well for generating awareness and building capacity. The second question is about right of grievance redress of consumers. While you have briefly touched upon it, but the idea is to ensure readily available means of registering grievance. Now, we have seen in other sectors, use of such language is perhaps misused, and there is just a tick the box check or check the box sort of a practice. We need to avoid that in this law, and some principles could be ensured if those are provided under this law, and we'd be happy to make suggestions. And lastly, the scope of public interest under Section 8 of deep consent is quite broad. It includes things like credit scoring and also recovery of debts, which could potentially be harmful for consumers. There could be checks and balances which could be built to prevent that and ensure consumer interest is upheld. So with that, thank you so much, and look forward to engaging with you further.
In any case, you must also be submitting your feedback and recommendations as part of the feedback that we have already designed to get it through MyGov platform. So I next move to Rahul Sharma. Rahulji, you can ask now the question.
Sir, thank you for the opportunity and thank you for the consultation. So my question is specifically with regard to the data that is coming in for processing of foreign nationals. Now we understand that the government isn't interested in collecting data or gathering data of the data processors like TCS, Wipro, which process client data. But here we are exempting the data under Section 18. So, and with the wider government exemptions, do you think that it creates a wrong perception in terms of how we are envisaging the larger ecosystem for providing the assurance to the clients and stakeholders that the data here is safe for processing? Plus, sir, there is no, as we have seen in the Schrems 2 case, the main criteria for adequacy, you talked about, reciprocal arrangements with other countries, is about grievance redressal of foreign nationals' data when it comes to India for processing. So, how are we ensuring that part is built into our legislation so that we take care of that? And sir, related question is on sir, cross-border data flows, which is happening. So, like you discussed about, there will be certain time period which will be granted for ensuring that the data processors can transfer data outside India, and there will be an appropriate framework that will be laid in place. But sir, we are talking only about the transfer of data by the fiduciaries. What about the transfer of data which is directly done by the citizens for accessing various services? So what are the conditions for data storage or transfers for that? Thank you, sir.
It does by the on the issue of the foreign citizens' data being processed in India. Obviously, this is a contract entered into by an Indian technology company and customers or clients abroad. None of the industry participants have said that they want this. The government of India's role or writ does not extend to protecting the rights of foreign citizens' data. That's how we see our role and the design of the bill. But if it was the case that industry wanted to be able to tell foreign clients that we have these restrictions that are imposed on us, conditions that are imposed on us that make India a better place for processing your data. I mean, I see no reason why we can't do it. But from our conversations with the industry, they don't particularly want it, and they have neither asked for it. But if there is anybody here from industry who wants to suggest that, we are happy to look at that.
If I may.
Yeah, go ahead.
See, in any case, in GDPR and other things, nothing prevents them from contractually taking on additional obligations to comply. So if I am a data processor handling foreign data for their purposes, I can certainly go beyond Indian law and offer additional contractual obligations, liabilities, etc. And that is how business is happening today also.
So just because you just mentioned if anybody's. So, sir, the problem is that this is a clause that's designed to just resolve conflict of laws issues. You don't want to enter in a scenario where Indian law prevents you from complying with your standard contractual clauses with your European controller. The issue might be in the language that it says that it will be by the processing of personal data of data principles outside India by any person in India, which includes any data fiduciaries in India. You may want to look at the previous framing of this exemption from the previous versions of the draft, which is limited to data processors or classes of processors. So, got it. That was the suggestion.
My request to everybody would be, if you have noticed this time, the bill consultation on MyGov is structured. It is clause by clause. And then if you have a chapter as a whole, and then finally the bill as a whole. And we have got a very robust online process. Don't imagine if you are not saying here, there is some formality which is happening over there, the written submission, nobody will read. No, that's not the case. It will be very discreetly and very systematically read. So I would suggest don't only flag an issue like the Honorable Minister is repeatedly saying. If you have an alternate formulation which fixes the problem, explain the issue and then go ahead and suggest what you feel it should read as. That will be more useful than simply making a point or pointing out an issue. But that's beyond this today's session. You have window till the 2nd if you feel like to refine your thoughts, and please suggest an alternate formulation.
Yeah, and I would really encourage that. Instead of, like I said it in the beginning, there is a tendency for us to stray into giving gyan and advice, which is fine. I appreciate that. But if you also accompany with that language, that will make our job easier. Yeah.
And then you can keep the strategic backup of government to decide whether by rules, because today you are exempting and that same framework by way of rules under IT Act. But when you hard code it into the substantive provision 18(1)(d), it reduces your strategic ability vis-a-vis adequacy. So you can just, if 18(1)(d) gets deleted, it'll just give
Anyway, last question and then we'll wrap it up.
Sir, Abhishek from Cyber Peace Foundation. As sir, for the deemed consent, the provision, sir, the third illustration in the provision itself, sir, talking about sharing of biometric data by an employee for fulfilling the attendance. So we feel that it will also be submitted as recommendation that this particular illustration in itself seems a little flawed. So much more generic illustrations to be involved in the bill to make the application and the interpretation of it easier.
Fine. So why don't you suggest that?
Yeah, so we will definitely.
Anything else? Done? Yeah. So look, it's been 1 hour 45 minutes of useful engagement, and notwithstanding some of the skepticism in the room, we take this job pretty seriously of creating a high quality, durable piece of legislation, and that works. So in a sense, we have a built-in incentive that we want to make these legislations work and be successful. So I thank you all for your input. And again, I will just repeat for all of those who have given us advice and wisdom and all of that, please feel free to back it up with some pieces of paper or an email. It's easy to send us an email. Then the process will be useful for us to sort of take all your inputs and see whether they fit into any amendments or changes in the bill. Again, thank you all and enjoy your weekend and Merry Christmas to all of you. Thank you.
Yeah, so before we close, maybe I'll just like to present a vote of thanks. On behalf of the Ministry of Electronics and IT, we are thankful to Honorable Minister Sir for having spared and having grossly engaged with you all. Thank you all of you, whether you have joined physically here or maybe through the VC. Your suggestions are welcome. They were very good. And we will request, as our Mantriji has said, that please not only just comment, but also provide the alternate and solution. So be focused on the solution rather than only the problems being raised. And of course, I am also thankful to my team in the Cyber Law and Data Governance Division, the NEGD, National E-Governance Division of Ministry of Electronics and IT, who at a very short notice organized this event. So thank you very much.